Nobody in court.
Item number 1 to 3.
May it please your lordships. Lordship, I pray for a short pass over, lordship.
What is this matter about?
Your lordship, we have preferred an appeal against the judgment passed by the learned single bench, your lordship.
Please speak louder, we cannot hear you.
Lordship, we have preferred an appeal, your lordship, passed by the learned against the judgment in order passed by the learned single judge, your lordship. Lordship, we have also filed an application for continuation of delay of 4 days, your lordship.
4 days.
4 days, your lordship.
Have you served?
Your lordship, we have.
For the state, I am here, your lordship.
We are confirming the delay?
1 to 3. Your lordship, only the private respondent are there, your lordship.
Sorry?
Private respondent are there. So far the state is concerned, I have no objection, your lordship. But the only thing that a private respondent, they are there, your lordship.
Have you served them?
No, your lordship, we have not served them, your lordship.
You have to serve them.
Lordship.
So far the state is concerned, I have no objection, your lordship, for continuing the delay.
All 3 appeals are together
Yes, your lordship. They are identical, your lordship.
from the same judgment.
Yes, your lordship.
One common order. Each of these appeals accompanied by an application under Section 5 of the Limitation Act 1963 for condonation of 4 days delay. Is preferred against the judgment and order passed by a learned single judge in a writ petition. Let a copy of the Section 5 application be served on the respondents and an affidavit of service filed in this court by 25th June, by 26th June. List the appeals along with the Section 5 applications on 30th June.
30.
Lordship, only the notice will go in respect of private respondent number 4 and 5, your lordship.
No, let it go to all.
All, lordship.
Let it go to all. And you don't openly say, I have no objection. You will get into trouble with your state. You leave it to the court will condone the delay.
Lordship.
My lord, 1, 2, 3 is represented by the AG, my lord. So we,
Let it be. It is very good and gracious on his part to say he has no objection, but on behalf of the state, it should not be said. It said, I leave it to the court.
Lordship. Oh, Lord, yes, Lord.
my lord, only one aspect, my lord. But the learned single judge is directed for re-tendering the matter, my lord, within 3 months' time. If some kind of status quo would be directed.
All right. Pending admission of the appeal. The appeal is by the state or by
By the successful bidder, my lord. I was the successful bidder, my lord, and that has been set aside, my lord. And the re-tendering has been directed by the learned single judge.
What is the time for compliance of this order?
My lord, the learned single judge has said that state will float tender within 3 months' time and complete the exercise within 3 months.
3 months.
3 months, my lord.
That is expiring.
My lord, 1 month has expired, my lord. 2 months. But because if they float the tender, my lord,
But still you have 2 months time.
2 months' time still there. But state should not float the tender in the meantime. That's the only thing.
Till admission of the appeal. Or until further orders, whichever is earlier. We simply extend the time for compliance of the impugned judgment and order. Full stop. The respondents shall also not take any steps in contempt or for enforcement of the said order.
My lord.
Apply.
That will-
Deeply.
Full stop. This order is without prejudice to the rights and contentions of the parties.
Lordship. Apply, your lord.
Oh, deeply.
Number 4.
May it please your lordships. Lordships, firstly, I would like to apologize before this honorable court. This honorable court, by order dated 16th May 2025, had granted liberty to me, to us, to the petitioner to file the response to the report submitted by the state by the 6th of June. But my colleague who is dealing with the entire research in the matter and everything, his father expired. So I could not file it within due time. I have filed it day before yesterday.
All right. Where is
My lord,
the
we have just received the copy, my lord. We'll require some time to go through the affidavit.
what have you stated in your rejoinder?
Lordship, in the rejoinder, we have given a detail of what had happened at the different inspection spots where the petitioner could go. And as regards the allegation that he did not attend in Khasi Hills and Jaintia Hills on the ground that he has security reasons and no FIR was lodged by him, we have stated that...
No, it's only on the point that they found no overloaded trucks.
Lordship, on that also we have satisfied, we have written in the report, in certain places like Tikrikila, Bajengdoba, there is no weighbridge. With regard to Tikrikila and one more area, it was mentioned in the year 2023 that it has already been set up, but it is not functional.
No, the
But there is no
exercise
weighbridge.
was carried out in 24 weighbridges. In none of them, any overloaded truck was found to pass.
Petitioner
Lordship-
was present as well, my lord.
Lordship, petitioner was not present in all the weighbridges because with regard to Khasi Hills and Jaintia Hills, he was having a panic attack and he was scared that something might happen to him, as has happened to previously one police inspector also and to 2 social activists also. The attempt to murder was done. And SIT probe was also directed with regard to
Those
the
are different
inspector.
issue, my lord. That is not...
Lordship, the issue, those were also related to trucks and weighbridges and coal, etc. And in the instant matter also, the status is the same. On the days when the petitioner...
Where is the rejoinder?
Rejoinder is on record, Lordship. I have enclosed photographs also, Lordship, where it shows that there are no weighbridges. People are standing on the road and checking. If your Lordship kindly sees page number 22.
If your lordship wishes to see in brief what is there in the rejoinder, I have made a short compilation.
Give.
The rejoinder points only, nothing else.
Let the state respond to it.
Lordship, I humbly pray that the state may be directed to make these weighbridges operational because it has been lying closed, shut down since the past 2 years.
First, let them respond to your rejoinder.
Lordship.
Then.
And their additional affidavit speaks for itself. They have themselves admitted that the weighbridge at Dalu can only weigh up to 10-wheeler trucks. But the trucks which are going to Bangladesh from Bhutan via Assam and Garo Hills, those trucks are 12-wheelers or more than that. So those trucks cannot be weighed at Dalu.
12?
12-wheeler or more than that. So those cannot be weighed at Dalu. This was stated by the state government in their additional affidavit filed before this honorable court. And I've highlighted that part in the synopsis which I have just submitted.
You are saying that in Dalu there is no weighbridge.
There is a weighbridge, but that can weigh only up till 10-wheeler vehicles.
If I can submit, my lord, their main allegation was, my lord, there was no weighbridge at Dalu.
It was
Whereas, my lord,
non-operational.
page number 25 of their own, this affidavit, my lord, may kindly see. Page number 25. Page number 25 of this rejoinder affidavit, my lord, it clearly shows, my lord, that the weighbridge is available, my lord. It is present there, my lord. Whereas in their entire petitions, my lord, they have said from the very beginning, my lord, there is no weighbridge at all at Dalu, my lord. That is their main contention, my lord.
Lordship, when we had gone for
They have not done proper inspection, my
When
lord.
we had gone for an inspection personally, Lordship, without there being any direction from this Honorable Court and without the Commissioner of Transport or anybody knowing about it, not a single man was available at the Weighbridge. It was shut down.
Their contention
It
was,
was
my
shut
lord, there
down.
is no weighbridge at all, my lord. And this weighbridge is functional, my lord. A bunch of
As per page 6 of the synopsis, according to your report,
yes, my lord.
there is no Weighbridge. He says there is, but only for 10-wheeler.
Yes, Lordship. I'll point out the paragraph which has been.
My lord,
Supplementary
these
affidavit.
weighbridges, my lord, they have the capacity, my lord. Now those vehicles which are more than 12 wheelers, my lord, it cannot be weight in this weighbridges, my lord. And my lord, as far as the vehicle from
Paragraph 3 and 4 of the
vehicle
supplementary
from Bhutan are concerned, my lord, I have already filed an affidavit, my lord. There is an agreement between India and Bhutan, and
Transit.
yes, my lord. So for any vehicle, my lord, which passes through India, my lord, from any vehicle coming from Bhutan, my lord, it has to be followed as per the agreement which is there, my lord, between the two countries, my lord.
Agreement, Lordship, cannot be.
My lord, they have to
violative of
challenge
the
if that is the
statutory
case. This is
obligations.
two sovereign countries entering into agreement, my lord.
But there might be other 12-wheeler trucks also, Lordship, which are passing from there. It's not
My
necessary
lord,
that.
entire my lord,
Lordship,
case is, my
there
lord,
is-
baseless, my lord.
Lordship, there is one more important point, Lordship. 83 trucks have been caught in Bongaigaon, which coal-laden trucks.
I've
and
seen.
Out of that, 38 metric tons was being weighed of one particular truck.
What is the,
And the sources from Meghalaya, they have been.
what was the declared quantity? What was the excess? That is not stated.
Lordship, we have we
As
had
per
filed an
as
RTI.
per the challan,
Lordship, we
how
had,
much was loaded?
Lordship,
So how much was excess?
Those vehicles
Lordship,
are, my
there
lord,
were no challans. There
that
were
is
no documents.
within jurisdiction of different state, my lord.
If I may take your Lordship to the show cause notice which was issued by the GST, Lordship, at page 66. Page 66 is the typed copy of the show cause.
Please take down. This public interest litigation is about operation of way bridges across the state. Stop. The allegation of the petitioner in the petition as well as in those voiced by his learned counsel in court, Miss Dr. P. Agarwal, learned advocate in court, is that there is absence of required way bridges in many places, comma, illegality committed by government officials at the "28 way bridges which are said to be operational, including their involvement in causing overloaded goods vehicles to cross the payment area with impunity. This, apart from anything else, has caused the loss of more than rupees 640 crores of revenue to the government. By our order dated 16th May 2025, we had made a specific direction asking the petitioner to respond to a report filed by the state further to an earlier order that it had carried out inspection in 24 weighbridges and in none of them any overloaded truck was found to pass. Paragraph, the petitioner has filed a response to this report. Full stop. This report has been seriously challenged. Stop. Some of the salient points taken in the rejoinder of the petitioner are total absence of weighbridges in vantage points, II, in quite a few of them, there is no facility to weigh the load carried by the truck. Full stop. It is simply done manually and in most cases incorrectly. III, goods are passing to Bangladesh without any proper weighment. Full stop. The weighment facility at Dalu. Is it Dalu?
Yes, Lordship.
Weighbridge located at Chaipani, Chaipani, Dalu, can only weigh trucks up to 10 wheelers, whereas the trucks entering India from Bhutan are 12 wheelers. Full stop. These trucks cannot be weighed. As far as the 12 wheelers are concerned, Learned Counsel for the State You end that. First paragraph. I end. Then next, as far as the inter-country transit is concerned between Bhutan, India and Bangladesh, Learned Counsel for the state submits that the said goods are in transit according to the treaty between the two countries. And the Indian government cannot act except according to the terms of the treaty. They have limited powers with respect to those goods. Paragraph. We are of the view that the revenue loss element is very important in this litigation. We direct the state government, we direct the Principal Secretary Transport Department to properly scrutinize this response of the petitioner and file a counter affidavit in this court by 30th June. List this public interest litigation for further consideration. Now, before that unit, a copy of the said report should be served upon the petitioner. List this public interest litigation on 9 July.
Lordship, if it could be on 7th of July.
All right, 7 July, the report to be filed by 5th.
Obliged, Lordship.
Number 5 to 8.
But these four matters are connected, arising out of the same common judgment, not of the single judgment.
May I please?
Proceed.
My lord, I am appearing for the respondent in item number 5 to 7, my lord. I am praying for some accommodation today, my lord. Mr. Paul has some personal difficulties today, my lord.
5 to 8.
5 to 7, my lord.
You're the private respondent or
Private account. They are the writ petitions, my lord.
what is the impugned order?
But here what happened, my lord, there is a central government organization called Northeastern Center for Technology Application, my lord, which is headquartered in Shillong, my lord. So this is a new establishment, my lord, and there certain scientific posts were advertised by the center, my lord, for recruitment. Now, our case is, my lord, the government of India. This is under the Department of Science and Technology, my lord. The directions from the ministry, governing ministry, was that these posts should be filled up on deputation basis, my lord, initially. But what the local center did, my lord, they made appointment on regular basis, my lord.
Appointment on?
Regular basis, regular appointments were made, my lord. And all the candidates who were selected were the internal candidates working on contract within the same organization, my lord. And our further case is that the prior approval over the governing council was not taken, my lord, before issuing the appointment. And the chairman of the governing council is the Secretary, Department of Science and Technology, Government of India, my lord. Now, the learned single judge said that the termination of their service But here what happened, my lord, when it came to the knowledge of the ministry that instead of deputation, permanent appointments have been made, my lord, and so there was an inquiry held, my lord, and pursuant to the inquiry, a decision was taken to scrap all these appointments, my lord, and issue fresh advertisement for filling up on deputation, my lord. Now the learned single just set aside the decision, my lord, and directed for regularizing all of them, my lord.
Was any step taken against the officer who had initiated the...
My lord, even that is a direction, my lord, in the inquiry report that steps should be taken against the officers who are responsible for this, my lord.
May I please, Your Lordship, I am appearing for the private respondent in item number 8. My Lord, in this case, what my learned friend has submitted, facts are not exactly that, my Lord. In the advertisement itself, it was clearly mentioned that the post will be first filled up by deputation. Even in the guidelines for applying for the post, it was very clearly and categorically mentioned that a post will be filled up by deputation. And only if the deputation is not there, then on regular basis, my Lord. And there were applications who applied on deputations, but the screening committee, those who applied for deputation, those were not screened because there were some defects and some requirements were there. It was not that no attempt was made for for appointing on deputation. My Lord, there is no challenge to the entire procedure of selection. There is no challenge to the screening committee's decision, the constitution of the selection committee. And there is no challenge to that. And through a duly appointment procedure followed as per the rules, the candidates were selected, my Lord. And after the selection, they were also issued appointment letter with post facto approval, which has been given by the committee itself, the General Council, which constitutes the chief secretaries of all the states, my Lord. In that meeting, they have all of them duly given their approval to the appointment. After the appointment, they have joined, the candidates have joined. Thereafter, on the basis only for this particular post, they have come up with that they say that there is a representation by somebody without giving any show cause notice, without giving any opportunity of hearing. They cancel this on the basis of a so-called report. What prompted to institute the,
you got the point.
Internal committee? My Lord, there is clear approval by the General Council, and the Director General is empowered under the rules to sign and issue all the things with so far as service contract is concerned. There is no dispute. They have not challenged. And by the same order, my Lord, in a very pick and choose manner, for the post of advisor technical, same advertisement, same recruitment process, same thing followed. For that post has not been cancelled. And there also it was post facto approval was given in that post also. That post they have not only this, and the fact that all the appointees were internal candidates is wrong. So far as this particular present petitioner is concerned, my Lord, he was working in Basin Development Government of Meghalaya.
Where is Mr. Paul?
Today he has some personal difficulties, my Lord. My Lord, may fix it next week, any day, my Lord, convenient to your Lordship.
We will hear it out. Monday we will hear it out.
My Lord.
Monday.
Mr. Deputy Solicitor General, just consider this point,
My Lord.
that if an authority represents itself to be empowered to make a selection or recruitment process, an authority of the government, not an outsider or an interloper, and makes that representation with, you see, the proper paraphernalia, like an advertisement with Ashok Chakra, etc., etc. The applicants who are applying are not required to check up the power of that officer to initiate the process. They are supposed to take it as true, as ostensible authority of the and participate. And thereafter, if they are selected, and it is discovered by his superior authority that he did not have the power. Now, in this inter se dispute, or rather
Exactly, my lord. My lord has
between the
gone to the exact
two authorities,
My lord.
why should a third person suffer?
Exactly, my lord. There are
my lord, I
the
admit to that
rulings of
extent, my lord.
Supreme Court is
A mess
also there, my
A
lord.
mess has been created in this matter, my lord, by the department itself.
Where for the mistake on the part of the
Because
appointing
suppose
authority.
the vice principal of a school issues an appointment letter to somebody, then the principal comes up and says he or she has no authority. Now, in this inter authority dispute, why should a third person be roped in if that person had some semblance of authority at the time of initiating the action?
My lord, I admit to that
If
extent.
he was a Group D or Class 4 staff issuing the invitation to participate in the selection, then anybody will say that he has no authority whatsoever.
My lord, the Director General has issued the advertisement, my lord. This matter. I admit to that extent. My lord.
Only one post.
4 posts, my lord. The 4 red petitioners.
How long they are working?
Now almost
My
9
lord,
months more.
some of them
now
were
to
working
be-
on contractual capacity within the same organization, my lord. 21 they were recruited on per regular basis, and 22 it was set aside. Then they came by way of red petition. Otherwise, they are continuing to serve in the same organization, my lord.
No, here 4 are involved.
4 are involved,
They have been reverted to the original contractual post.
my lord.
No, they are still continuing.
the learned
They
singles are
still-
directed
Singles
to-
are set aside that cancellation order.
No, if the cancellation order is upheld, you will be reverted back to the,
Contractual, yes.
Yes.
or it will be filled up regularly and they will be ousted.
No, so far as this candidate is concerned, my lord, he was not working in the department. He was working in Basin Development Government of Meghalaya, and he had to, on his selection to this post, he had to resign
No,
from
if
that
the
post.
deputation is made, then you will be thrown out. The contractual appointment will end.
That possibility is there, my lord. I don't have exact instruction, but whether how many
You
posts are
get
there,
ready, all of you. Monday we will take it up.
my lord. One day.
Problem.
Dr. Mozika, learned Deputy Solicitor General, opens his argument in support of the appeal. Full stop. He does not conclude the same. Adjournment is also prayed for on behalf of
The respondent, my lord.
In item number,
Item number 5 to 7, my lord.
respondent numbers 5 to 7.
No, my lord, the respondent, sole respondent, my lord.
in items number 5, 6, and 7. The 4 matters, my lord.
On behalf of the private respondent in item
Can it be-
item number
5 to 7, my lord.
5 to 7. A common order in support of the appeals. Sir. List these appeals for further hearing.
My lord, can it be fixed on the 23rd after 1 week, my lord?
Why? You have difficulty.
I have the chief person.
I'm here, my lord.
23rd, the next Monday, not this.
All right.
Much obliged, my lord.
On making it 24th.
Obliged.
My lord.
By consent of learned counsel for the parties, this appeal is fixed for further hearing on 24th
My lord.
June.
Deeply obliged, your
Deeply.
Single bench will sit immediately.
On last occasion, Mr. Paul appearing for some of the accused, my lord.
Yes.
Paid for-
Please, Lordship. Lordship, we have filed the compilation. We'll serve the copy to my Lord Senior. We are seeking, my Lord, a week's accommodation, my Lord. Next week, end date, my Lord. He's having some difficulties, my Lord.
The single bench is taking one matter. It should have been
My apologies,
informed to the court.
Absolutely, my Lord. My deep
Mr. Paul
apology.
seems to have difficulty every second day.
My deep apology, my Lord.
What is this compilation about?
This is, my Lord, the documents which we are relying, my Lord, during hearing, my Lord. On the last occasions, we are prayed.
This is the compilation.
The statement under 161 and the charge sheet, my Lord. The complete charge sheet, my Lord.
But Dr. Mozika, what is the effect if the charge sheet is found to be without details or specific charges and found not to disclose a specific offence? Then has the prosecution the power to file a fresh charge sheet?
My lord,
Please find out. It's a question of law.
Yes.
Because the Article 20 or something of the Constitution says that he cannot be prosecuted twice.
but 20.
Because the effect will be discharge for a vague charge sheet. Now, after that, can a fresh proceeding be instituted with a detailed charge sheet?
I'll examine the but double jeopardy, as far as I understand, my lord, the law says that cannot be punished twice, my lord. Can be prosecuted twice, but cannot be punished twice, my lord.
No, you see, give us.
Prosecuted and punished, I think. I'll look up for the law. There's some
You
Supreme
have
Court
the Constitution. Or take it out from your.
I'm trying to get from mobile, my lord.
Yes. Or you read this. Article 20, sub-article 2. No person shall be prosecuted
And punished for the same
and
offence,
punished for the same offence more than once.
my lord.
Say, for example, in the course of prosecution, the judge finds that there is no evidence against the accused and say he is acquitted or at the first stage discharged.
Discharge, my lord.
Then the prosecution cannot make a further investigation and say, yes, I have found evidence against him, restart the trial. I think that cannot be done.
That can't. Because there are parameters.
Because they have raised a very tricky point. They have said that these statements have been signed by the results, 5 officials, the mark sheets and all that, 1, 2, 3, 4, 5. Perhaps the accused signature is not there, as the accused was the head of the department as a minister or
Yes.
secretary, whatever.
Yes. The only allegation is that she sent some chits to the director of education.
And the interpolation has been made by the accused. Now they are saying
My
that
lord.
how that interpolation has been made. When there is no record of any writing
Yes.
or any mark or any action on that particular document by the accused.
Yes, my lord.
So they are saying there is no specific charge,
Yes.
that how he or she is involved. Please address that, because that will be of vital importance.
I'll assist your lordship on that with supporting law, my lord.
Yes.
And on facts also, my lord, I'll try to address your lordship.
When should we keep it? On the day convenient to him, you have to appear.
My lord.
And if Dr. Paul has some difficulty, you will do the matter. You tell us.
Well, I'm here, my lord. It's for them, my lord.
Because this matter cannot be kept hanging.
After 10 days, my lord, because quite voluminous they've given, I'll just examine that. 10 or 15 days, ma'am.
Your accused number?
My lord, 2.
Adjournment is praised on behalf of Dr. Paul appearing for accused number 2.
Doctor, not doctor, my lord. He's not doctor.
All right. With Mr. Paul Leonard, senior advocate, appearing for accused number 2. By consent of learned counsel for the parties. 26 June will be all right?
Yes.
My lord, I have one request on behalf of accused number 1. Inadvertently, one page of the impugned order is missing from the court's record. If I can be given permission to file it with the written submissions, I've handed over the written submissions in the past along with the supporting documents. I can
You
also...
bring it, we will see.
My lord?
You bring it, I will see.
My lord.
This matter for further hearing on 26 June. At 12:45 p.m. or after? No, at a time indicated in the cause list.
Ma'am.
My lord.
The subsisting interim orders will continue.